And you can be seated. The matter before the court is Somerset 23-261, State of Maine versus Dalvin Peguero. And counsel are present. We're hoping that I'm hoping that we're streaming live on the web, both orally and by video, although that seems to be unclear these days. In any event, if counsel are ready to proceed, I'd like to start by asking you to introduce yourselves by saying your names for the record, together with the party you represent for the appellant.
James Mason for the appellant, Dalvin Peguero.
Morning, Your Honor. Jason Horner for the appellee, the State of Maine.
Thank you. Counsel, Mr. Mason, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. May it please the court. I'm happy to take questions at any moment.
I was going to say, I noticed that you didn't reserve any time. Can I ask you about the warrant? I mean, in this case, it's not looking at the warrant itself. It's not just the information that's included in the affidavit, but the warrant itself includes a description that the campers are on the premises, has a photograph, et cetera. I understand it doesn't specifically say to search the campers, but why isn't that sufficient?
What I'd first note is what the warrant says is that this is a single-wide multicolored trailer with 2 campers in the front of the property. And that was actually in the start of the order before they...
That's the description of the property, a trailer with 2 campers.
I would hold that, I think that with, that is different than that includes, because it could be describing the property itself. If there are other structures, because there were 2 pictures that were included in the warrant, but if there were structures that weren't even part of the property.
But we look at the affidavit too, right? Do you agree with that?
I agree with that.
And the affidavit points out that Mr. De Jesus, with an accomplice, previously operated out of a camper on the other property.
I would agree with you, and I would emphasize those last 2 words of what you said, that other property.
But with the other property, but that his modus, the state here is alleging accomplice liability. So Mr. De Jesus' modus operandi, you could argue, is operating with an accomplice out of a camper that was on, I guess, this individual's property. So they're saying either direct responsibility, which is a viable argument, but also accomplice liability. So let's look at how Mr. De Jesus does his business. And the affidavit says he works out of campers on property owned by Mr. Was it Merrow? So here, that's in the affidavit. So here we have the pictures of the house with the campers prominently posted up there. So following up on the Chief's question, isn't that broad enough to wrap around the campers out front?
What I would note in paragraph 12 of that affidavit, I'm sorry, I don't have the appendix page, but it's in paragraph 12, is that the only reference, other than just the descriptor at the top of it, to the camper is eventually CI, and there's a CI number, located the correct driveway and walked to the camper on the rear of the property. There's actually no reference in the affidavit itself that there was any activity that came out of the camper. Obviously, an inference could be made on that, but if we're going to look to the 4 corners of the warrant and to the affidavit, which is incorporated in that, it just mentions it, and it's not even on that property.
But on the search warrant itself, it says the place or person to be searched is 614 Dexter Road. And then it gives a more full description. But the place to be searched is 614 Dexter Road. And the description is it's a building with, or a trailer with 2 campers in front. It doesn't even say building. It says trailer with 2 campers in front. But the warrant was really to search, and it's 614 Dexter Road. And there's no question that these campers were at 614 Dexter Road, right?
I'd agree with you. There's no question that they are on the property boundaries. But the affidavit and the warrant have to have a certain level of particularity. And I know obviously the argument is that this is particular enough. I, of course, maintain that it's not.
Are the campers buildings or vehicles? I know you talked about this.
I would say there are others.
There are
because there's a box that covers that. They're not a building. I think there was any question that there was a
And
building.
if it happened to be a camper that had an engine, the truck camper, then it would be a vehicle.
That would certainly be very strong argument that it is
Would
a
you be
vehicle.
arguing then that you could search the truck but not the camper in the back?
Well, if the truck, first of all, they weren't attached.
I know.
So there was
But
not a
were
truck
they-
attached to it.
But were they appurtenances?
And I'm going to say they're not appurtenances, because first of all, we haven't really kind of used that phrase here in Maine. That was kind of borrowed in the state court, but we've certainly had a couple cases where they've talked about it in the context of a sort of a subsidiary or subordinate.
Curtilage or things like that? It does
Right,
happen.
and what this court has looked at, if they've looked at like a backyard and a septic tank, that's the Dignati case, and a detached garage, that's Brochu. When you look at appurtenances, that, when that word gets used in other courts, it's very clear, those are subsidiary, these are subsidiary things, like
Does it
storage
matter if it's
closets,
a
cabinets, my favorite, a birdhouse. These are things that they're not the property, they are things that have been put in there.
Does it matter if it is a separate dwelling? I mean, somebody's living there. This is,
I do believe it matters because it shows that it is not sort of subordinate to the property itself.
if it's
So
a
all the
dwelling,
indicators-
if it's a dwelling, does it therefore get included as a building?
I don't think so, because a dwelling can sort of take on all sorts of, it can take on all sorts of forms. There is, the form kind of gives clear indication of what's contemplated when a search warrant. We have a building, we have a vehicle, we have a person, and we have another. And the other wasn't checked anywhere. And I think the reason you have another, you have a catch-all, is because there's an acknowledgement that,
So if they checked the other, it would have been okay.
I think it's a
So
very
officers
different
should always
story.
check the other in every search warrant they.
If you're contemplating that something like a camper that somebody is living in is going to be part of the warrant, because I would say the fact that it's mentioned in this descriptor of the property goes into our favor, because the reviewing judge who looked at it saw that it was there and could have marked
Can I take you out of the camper for just a moment? And move on to the other issue, which is that, as you know, the court allowed Mero to talk about Mr. De Jesus
Yeah.
trafficking quite a bit, and that is perhaps the centerpiece of your argument. But in looking at that, the state made very clear that part of their case was accomplice liability. In order to prove accomplice liability, they'd have to prove that someone else is committing a crime and that your client assisted or some way facilitated it. So that opens the door to evidence about what the principal is doing, i.e. committing the crime. Isn't that black letter law in the state of Maine?
So what evidence of intent, I think, comes into these other events, how it can be used is to explain the event that's at issue. I know
Crime,
the crime.
yes.
And so I think the state, in its brief cited Cody, I think what's probably a more relevant case is Osborne, which is a much more recent case. Mr. Warren's very familiar with it because it was his case, where you looked at the dealings between a confidential informant and the alleged drug dealer it's a previous event, and they weren't charging that previous event, but used the previous event to explain the communications that happened at the event that was part of the charge. There was no talk about drugs in that case, and they were saying, there's no talk about drugs, because they knew they didn't need to talk about drugs. They were talking in code, and that's sufficient because we know that because of this previous incident. And all the cases that this court has dealt with, or these, has involved
Well, I thought your
essentially the-
argument was that he was being painted as part of a larger cartel and bad people who don't speak English are coming to Maine.
It is, that's the inference essentially that the state was making, is they're saying he was involved, this had happened before, this was sweeping through this
I'm
area.
going to suggest I read the transcript, and the evidence was limited. I mean, they didn't get into everything that they believed that Mr. De Jesus had engaged in all the activities. It was somewhat limited. Were there specific questions or testimony to which there was objection that you think is objectionable, or just in general? I mean, you can't really draw, where I'm trying to go is, it's pretty hard to draw, start the evidence of, we arrived on the premises and, I mean, you know, you give the jury some background as to why you're there.
Well, and certainly if I was going to throw out a generality, I would say we shouldn't use deals that happened 2 months prior in a different town. I think what some of the testimony was is that
But were there specific objections to question or motions to strike during the, I know there was a motion ahead of time, but,
I believe that there was arguments during the trial. They had the whole voir dire because of it. And then I think the court made its ruling. There was back and forth between the parties about what that ruling actually meant. I don't believe at the moment that he was testifying, there was a specific objection raised by the party, but like that had been litigated not only pre-trial, but during trial. I would.
But the court had already established the parameters of how far they can, you can't say this, you can't say that. you can do
Correct.
this, so.
and you agree that it didn't, are you essentially agreeing that they didn't go beyond the parameters of what the court was ordering?
No, I believe the court allowed them to, go into this area where he could say, yes, I knew him because I knew Arias de Jesus because he was doing drug deals on my property. And he was doing it on my property, not here, but elsewhere. And so, no, none of the things like vast drug cartel or Dominican
Well, and that's what I'm trying to
cartel.
understand.
None of that.
I understand you may disagree with the court's ruling. Are you suggesting that any evidence came in that was beyond what the court had ruled?
No, I think
Okay.
the court's ruling itself allowing what did come in is the error.
Okay.
I don't believe either of the party, other than, yes, they certainly referenced these guys. They referenced Mr.
So if the court had said, you can't offer any evidence about Mr. De Jesus drug dealing, the state would say, well, wait a minute, accomplice liability, you've prevented us from offering proof of the principal offense to which he was an accomplice. That would have cut the state off at the knees.
Except Mr. Arias de Jesus was charged with the events of September 1st. He was charged with those same events. If they want to charge him with accomplice liability for the acts that they're saying Dalvin Peguero was an accomplice to, it's there. He's charged. They didn't have the same trial, but
Can I ask you, as your time is running down, just on the issue of perhaps, if it was error, whether harmless error, there's a pretty strong case here that Peguero had a box of drugs he came out, put in the truck. Mero testified to all this, gave him the address of where he was going. He knew he was going to make the drug deal. Isn't that, standing alone, sufficient to sustain a verdict here of trafficking?
I don't believe you can get to that. Your question goes directly to our last argument about the sufficiency, but I don't think you can get past the fact that it's being painted with such a broad brush that the jury, when he was dealing with a Spanish-speaking, dark-skinned Dominican, saying, and there's suggestions that this was not the first time this was part of a drug conspiracy, even if an
You're saying they couldn't
enterprise.
look at those narrow facts by themselves in
I don't think
isolation?
I don't think you can tease those apart, given the kind of like the nature of it. I think because this evidence got in, you can't rely on just how they interpreted.
Just to tease out your last argument then, because there's not much time, the sufficiency of the evidence, I mean, you have to agree that if believed, Mero's testimony by itself about what they found in the car could be sufficient to sustain. But I think what I hear you saying is when you add in all this other evidence that you contend should not have been admitted, that you really, that by itself would require a vacation, even though technically there may have been sufficient evidence without it.
I certainly am not waiving our last argument onto the sufficiency evidence, but if you say, well, yes, there's sufficient evidence, yeah, I would say, but you can't get to that because of the fact that this other evidence came in and essentially tainted what could have been that verdict.
Thank you, counsel. Mr. Horn.
Thank you, Your Honor. May it please the court, counsel? On this particular case, I'd be happy to just answer questions.
All right, then I'll ask the first one on the issue we didn't talk about, which is the speed of the verdict. And you note that not a peep was said about this until the jury's discharged, there's no motion for new trial. So do we treat this as waived Do we use an obvious error standard? What should be our standard of, should we just say, no, we won't look at it? What should be our standard of review?
I think it's an obvious error standard, and it was not preserved because there was no objection at the time. There was no motion for new trial, and I believe that leads us to an obvious error standard.
What's the error?
There's not one here.
But it is a bit disquieting, you know, we've all been there, you go out, the jury has it, you walk out, and, okay, I'll just do some work on another case, we've got a verdict. Yeah, it's a little, doesn't that cause you a little bit of pause, a little bit of concern? Obviously, they walked in there and there was no meaningful discussion, deliberation, debate.
Not necessarily based on the record that was presented to them. At the end of this trial, state's position is that they certainly had overwhelming evidence of guilt. And it's conceivable, of course, we don't know what goes on in the jury room, but it's conceivable that they held a straw poll immediately.
What about the fact that they didn't even have the exhibits to the trial? Was there a complete record, so to speak, before the jury in the deliberations room?
And at the point during the trial, all of the exhibits were extensively published to the jury at some point in time or another. So I know there's photos in the record. Certainly they had very large bags of drugs in front of them, as well as a great number of photos that were in evidence. And there was also the publishing of the lab result. So they had ample opportunity to view all of those exhibits in real time during the presentation of the trial.
Do you agree with your opponent's suggestion, well, I guess the perception, widely held perception, that it's a good chance that jurors would be aware of the fact that there may be an influx of drugs coming into Maine by folks who are, you know, not residents here, and that it's causing alarm and it's becoming a political issue for a lot of people, that this is a hot-button topic. I'll ask you, number one, if you agree with that concept, and number two, whether the courts and prosecutors should be aware of it as they present their evidence to avoid tainting it with perceptions that may or may not be on point.
And I don't know that I can speculate on the perception of the average juror in the community, but my understanding is we're bound to interpret that they are following their oath, which their oath asks them to set aside these preconceived notions and judge a case based purely on the record and the law that's presented to them by the court, absent some showing to the contrary. And there is no showing here. And it has been held that a short deliberation by itself is not evidence of misconduct in Cheney. And as opposing counsel candidly concedes, there is, in his terms, a mountain of case law around the country supporting short deliberation times.
But in those cases, the data that we don't have is whether or not the fact that Mr. Peguero was a non-English speaking individual making a periodic trip to Maine under circumstances that would suggest drug dealing. We don't have any way to understand what went on in an individual juror's mind, saying, we've got to stop these people from coming here, which would be an improper conclusion. But are we to be just turn a deaf ear and a blind eye to the fact that this may be going on? This is maybe not, I'm going beyond this case, but for big ticket things for prosecutors in the court, is this something that should factor into our consideration of particular cases?
I don't think it's something that should factor into particular cases insofar as it's difficult to envision what the alternative would look like. Is there's a general rule and then there's a different rule for deliberation times, assuming you're a minority or a non-English speaker, which would be inequitable and would presuppose that the jurors are incapable of following the law and in the instructions and their oath that they already took to the court, which much of our jurisprudence is founded on the understanding and impression that they are going to follow that.
Well, aren't we also stuck with a limited record because the defense counsel did nothing? I mean, the trial judge asked twice before the jury was discharged. Anything you want to do, anything you want to put on the record, he could have gone through each of the jurors, made sure this is really your decision, which is what's giving me pause about it's got to be really obvious error, and we don't really have a full record to show that anything bad was going on, do we?
I agree. There's not a record to show anything bad going on. As Your Honor points out, defense did not raise any kind of objection to it at the time, did not do anything to suggest foul play or preserve such a notion at that time, and again, didn't file a motion for new trial either. So
Would it be best practice for a prosecutor to poll the jury in the event of a very brief verdict like that? We're going way outside this case here, obviously, but should you want to make sure that there was no improper process here? I've never heard a prosecutor ask for a poll of the jury on a guilty verdict. But in a case with a short verdict, a short deliberation period, is that something that maybe should be a best practice?
And as Your Honor points out, I don't think I've ever heard a prosecutor ask for one either, but your question is starting to make me wonder if I should. Any other short verdicts?
My other question is, should you always check off other on the search warrant box?
Perhaps.
Counsel, let me ask you this, going to the issue of the evidence of other events involving Mr. De Jesus. There's no evidence showing that Mr. Peguero was involved in any events prior to the day of the search, correct?
There's nothing in the record suggesting that.
And obviously, there was evidence in addition to, the search of the vehicle he was in. There was evidence showing that would tend to lead one to believe he was staying in the camper where all the money and the rest of the drugs, et cetera.
Yes, Your Honor.
And that in and of itself, the evidence from that date could support the accomplice liability. How is evidence, if you can't tie him to events occurring before that day, how is any of that evidence relevant even to an accomplice theory?
Your Honor, the state's theory as espoused, even as distinctly limited by the trial court, as Your Honor has already pointed out, was that Mr. Peguero was an accomplice to Mr. Arias de Jesus, and intent was very much in question from the defense case.
Intent about what?
Intent to traffic as well as intent to even possess drugs.
But don't you have to show that in terms of what happened that day? I mean, if you can't tie his, if the facts are that he came up, that day or the night before or something like that, if you can't, we don't know. If you can't tie him to the events that Mr. De Jesus engaged in before that day, how does that bear any relevance to his intent?
Well, Your Honor, what we have here is a distinct combination of individuals and an ongoing scheme that Mr.
Well, you don't have a distinct combination of individuals involving Mr. Peguero. He may have been involved with other people. In fact, the evidence was it was a different person at some point that Mr. De Jesus was with.
That's correct, Your Honor. The evidence at trial was that Mr. Peguero would go to properties of Mr. Mero with essentially a
Mr.
revolving...
Peguero would?
Excuse me. I'm sorry. Mr. Arias de Jesus would go to a property of Mr. Mero with a revolving cast of accomplices with him. Why we think it was particularly relevant is this is not merely just talking about, hey, the other guy was involved in drug deals previously. It's the same co-defendant with the other same uncharged accomplice co-conspirator, Mr. Mero, on properties of Mr.
The fact
Mero
that he may
in-
have other uncharged, that Mr. De Jesus may have other uncharged co-conspirators still doesn't tell us why Mr. Peguero knows anything about that or why that is relevant to Mr. Peguero's intent as opposed to Mr. De Jesus's intent.
Well, to clarify, Your Honor, and we see Mr. Mero as an accomplice as well
I
to both
understand.
Mr. Peguero and Mr. Arias, and though uncharged. The intent of the scheme...
Except
that-
again, Mr. Mero didn't identify that he'd ever met Mr. Peguero before then.
That's correct. And however, And the intent of the combination is still relevant insofar as Mr. Peguero is now assisting the combination here in the moment. Since his intent is in question, it's fair to attempt to put on evidence to show what the intent of the combination he was now participating in was.
Counsel, did you even need to go there? I mean, did you not feel the evidence that you had with regard to the date in question in the event that Mr. Peguero was actually involved in was sufficient?
Your Honor, while I think a jury could certainly convict him based solely on the evidence from that date as well, that doesn't change the state's position that it's still relevant evidence that could further expand the jury's knowledge of the general scheme that they were involved with here, involving Mr. Merrow and involving Mr. Arias. And state would point out that evidence of prior drug sales has been found to be admissible to show intent previously.
But isn't that prior drug sales in which the defendant, the person whose intent you're trying to show, was involved?
That's true, Your Honor. And
Well, isn't that different?
well, it would be analyzed under different rule of evidence. Here, we're really talking on a pure 403 analysis because we don't believe 404 or 405 are really in play because it's not a prior bad act of this specific charged defendant.
Might be
or
pure
witness.
401. In other words, 403 would exclude evidence that's more prejudicial than probative. But I think the question that's being raised is it even probative of anything relevant to Mr. Peguero?
And again, Your Honor, one can't ignore the intellectual reality of the case insofar as there is a group of three people. The third prong is transient, not always the same. You have Merrow, you have Arias, and you have a helper. The evidence shows that Mr. Arias, with a helper, traffics drugs out of a camper on Mr. Merrow's property and has continued to do so. And
Means that evidence would be very relevant in Mr. De Jesus' trial.
well, I don't think we would be having the argument at Mr. Arias's trial. However, that does not change the relevance to the scheme. If you have an accomplice liability theory, a viable accomplice liability theory, the state should be able to put on relevant evidence that shows what he was an accomplice to, insofar as exactly what the intent of the scheme was. I agree and concur with the court that there's no evidence in the record to show that Mr. Peguero directly participated in the prior transactions. However, all of the other elements are identical. It's not just a bad act in a vacuum. It is, again, the co-defendant doing the same
So
thing.
if you have if you have Mr. De Jesus committing a series of thefts, he goes to a store, he does it in a certain way, he commits a series of thefts, he uses somebody as a decoy to commit thefts on various occasions. And now you have Mr. Peguero and you've charged him with theft on a particular day. Do you also get to put in evidence of all the other times that Mr. De Jesus committed thefts, even though there's no evidence tying Mr. Peguero to those thefts?
I saw the light go red for a second. Do I
Well,
have time to-
it's still yellow.
Okay.
Plus, you get to answer my question anyway.
Thank you, Your Honor. I would venture to say probably not, but that's distinct from this fact pattern because this is not merely him being associated with the same sort of offense. There's multiple different commonalities in play that make it relevant. Again, same MO, same camper, on the properties of the same other accomplice with the same co-defendant in exactly the same manner. There are multiple different things that come together to make it uniquely relevant to this fact pattern. In what Your Honor posits, it doesn't sound like you have an ongoing scheme between
Oh,
a
I was
static
positing that he was
organization.
using Mr. Peguero in the same manner, but we'll leave that one for now. Thank you.
Thank you.
Mr. Mason?
Thank you, Your Honor. For comparison's sake, it took you all about 30 seconds to come out from the door to sit down. That's about a third of the time, well, it's about a quarter of the time that was probably done with deliberations. You probably spent double the time that this jury was out deliberating, asking Mr. Horn questions about this very issue. I don't see how meaningful deliberation could have happened.
But is it preserved? I mean, don't we treat that as essentially juror misconduct? There was no polling of the jury, there was no motion, there was nothing.
I would say that it is preserved because the judge, obviously.
It was noted.
Obviously, an experienced judge sat on it for a while and was very concerned enough that he felt like he needed to do the research on the issue and come back and put it on the record.
Despite the fact that no one even thought that they would raise it as an issue.
The whole point that we talk about we needing to have issues raised is so that this court can look at the analysis of the lower court, and you have that here. That's why I actually don't think that it is a waived issue or even an obvious error. I think what you are looking at is a situation that there could have been nothing more than people walking into the room saying, everybody thinks he did it, right? Yep, knock on the door, we're done. If we find that that's enough, we really should stop calling it.
Should we be setting a bright line time? In other words, 5 minutes and 15 seconds? If it's less than that, it's misconduct?
I think that there's really can't have a bright line rule because you have deliberations. Justice Mullen used deliberations 12 times in his instructions. And if we just allow essentially like a vote, let's stop calling it deliberation.
But is
Let's
it?
call it a jury vote.
If you watch the evidence and you think, it seems pretty obvious to me, I don't know what we need to talk about.
We've tasked our juries, if I may finish that.
Go ahead.
We task our juries to deliberate, and we task our juries to meaningfully deliberate. And I think a simple vote and without any deliberations is not that.
Thank you, counsel.
Thank you.
Thank you. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. And with that, we'll be